You know, if you've ever lived in a neighborhood with a homeowners association, an HOA, you know they can be a source of some, let's call it passionate discussion, from what you can and can't put on your lawn to the specific approved shade of beige for your front door. But what happens when you start to suspect that the biggest decisions, the ones that really matter, are being made when no one else is in the room? It's a question a ton of homeowners have, right? You get the newsletters, you pay your dues, but do you actually know how the sausage gets made? Well, this exact question pushed one homeowner to take his HOA all the way to court, in a case that honestly has a fascinating lesson for pretty much anyone living in a planned community. So, we're diving into a 2020 case right out of Queen Creek, Arizona. You've got Kenneth Kassa, a homeowner, on one side, and on the other you have the Queen Creek Ranchettes HOA. It's your classic neighborhood showdown, but this one has some really important legal stakes. So on one side, you have Mr. Kassa. He's a member of the community who just got a gut feeling that something was off, that things weren't being run the way they were supposed to. And on the other side, you've got the HOA board, who were absolutely convinced they were doing everything by the book. The whole thing really boils down to one simple question. Were the HOA board's meetings on the level? Mr. Kassa and the HOA had completely opposite answers, and that disagreement sent them straight to the courthouse. Okay, so here's the he said, she said. Mr. Kassa's claim was that the board was holding all these secret closed-door meetings, and that doing so was a direct violation of state law. But the HOA fired back saying, hey, hold on, our own rules, our bylaws, say we only need one public meeting a year, and we did that. We're good. For Kassa, the argument was pretty straightforward. He basically believed that the one public meeting they held each year was just for show, a performance to tell all the residents what had already been decided in secret. He was sure the real work was happening behind those closed doors. But the HOA's defense, it was just as direct. They just pointed right to their own rulebook, the bylaws, and argued they had followed their own rules perfectly. They held their big annual meeting just like they were supposed to, and in their minds had done absolutely nothing wrong. So this brings us to the really juicy legal question. Who wins when an HOA's internal rulebook seems to say one thing, but a state law says something completely different? This is where the case gets really interesting. So first, let's talk about bylaws. Just think of them as the house rules for a specific neighborhood. The HOA's bylaws were clear. Board meetings had to be held at least annually. And that little phrase, at least annually, was pretty much the entire foundation of their defense. But then you've got the state law. This Arizona statute covers all planned communities, and it couldn't be more clear. It says that no matter what the bylaws say, all meetings of the board of directors are open to all members. The key words there, of course, are all meetings. So here's the bottom line, legally speaking. When there's a fight between HOA bylaws and state law, the state law is the trump card. It wins, every time. So given that, it seems like this should be a total slam dunk for the homeowner, right? Well, not so fast. Now, the law does have some fine print. It allows for closed meetings or executive sessions, but only for a very, very specific list of sensitive topics. We're talking about things like getting legal advice from a lawyer, dealing with lawsuits, or discussing confidential info about an employee. Common sense stuff to protect privacy. But everything else, all the normal HOA business, has to happen out in the open. And this list of exceptions, well, it turns out to be absolutely crucial. All right, we've laid out all the facts, we've heard from both sides, and we know what the law says. So now for the main event, the verdict. And this is where a surprising legal rule completely flips this case on its head. So based on everything we've just gone over, especially that state law that says all meetings have to be open, who do you think won? Was it the homeowner, Mr. Kassa, or was it the HOA? The HOA won. The judge denied Mr. Kassa's petition. I know, right? That seems to fly in the face of everything we just learned about the open meeting law. So what on earth happened here? This is the million-dollar question. If the law is so black and white, how could a judge possibly side with the HOA? Well, the answer isn't in the open meeting law itself. It's in a really fundamental concept of how our entire legal system works. The whole thing hinges on this legal idea called the burden of proof. It basically means that in court, the person who makes a claim, in this case, Mr. Kassa, has the responsibility to prove that their claim is true. It's not enough to just point a finger and make an accusation. You've got to back it up with evidence. So let's walk through the judge's logic here. 1. Kassa claimed the meetings were illegal. 2. That means he had the burden of proving it. 3. And this is the killer, the judge noted that Kassa provided no evidence of what was discussed in those meetings. He couldn't prove that the board wasn't talking about one of those legally protected, sensitive topics. And 4. Without that proof, the judge's hands were tied. He couldn't just assume they broke the law. Now, this isn't just some weird story about one neighborhood in Arizona. This case actually gives us some incredibly valuable and honestly surprising lessons for any homeowner who might one day have a disagreement with their HOA. So what are the big takeaways? First, state law is king. It will always override your HOA's rules. But second, just thinking something is wrong isn't enough to win in court. An accusation needs evidence. The burden of proof is real. And when it comes to a fight over secret meetings, the absolute key piece of evidence you need is proof of what was actually talked about. Without that, you could be 100% right in theory and still lose your case. And that leaves us with one last really tricky question. We have just seen that what was discussed is everything. The homeowner lost because he couldn't prove it. So if you were in his shoes and you suspected your HOA board was making decisions in private, how would you even begin to find the proof you'd need to win? It's a tough one, and it's definitely worth thinking about.